Okay, so we are starting on the judicial branch, and what we're going to cover tonight is the structure and power of the judicial branch. So we're going to go through all the background information you need to know about it. We're going to talk about the structure of it, the powers of it, things about judicial review, and then also the limits, because there are limits on judicial power. Over to Kirsten and Sue.
All righty. Thank you, everybody, for attending tonight. We're really super excited as this has definitely been in the news. So the judicial branch interprets the law. There are the levels of court that we will discuss tonight. Next slide. And remember, we have three branches. We separate the powers into legislative makes the law, executive enforces the law, and the judicial interprets the law. But the key to our country is that there are checks and balances between the three. And so our checks and balances discussion and our power of the court discussion are really important tonight. Next. So the courts really only have one role, and that's to interpret the U.S. Constitution and the U.S. laws. Obviously, the interpretation has changed through the years. The document has not, but the interpretation has. Next. All right. So here we go with the foundational aspect of our courts. And the word is precedent. It sounds like president, but it is not our executive president. It is precedent, the preceding case. This concept was brought over from England and we have kept it. And the idea is that any current case that is decided should be based on decisions in the preceding cases that were considered thoughtful, relevant, and really important. All right, next. So here is a chart, and it simply is showing that any decision that is made by the current or future courts absolutely must be based on the preceding cases that were accepted as really important and extremely thoughtful. Next. Another chart, please notice the district court at the bottom must accept all precedents from the Court of Appeals and the U.S. Supreme Court. The district court may never contradict those precedents, the newest and the most accepted precedents. Also realize that all cases begin in the U.S. District Court. Those persons unhappy with the final decision appeal next to the Court of Appeals and then to the U.S. Supreme Court. Next. So again, we're still in background information, getting background terminology down pat before we get into more, get into the weeds, get into more details. The U.S. district courts, the lowest level of courts, have original jurisdiction, which means the cases begin here, and these are the trial courts. These are the courts in which the facts are determined. What are the actual facts of the case? The how, the when, the where, the why. And in these particular case courts, the jury will determine, and this is the only court that has a jury. The other two levels do not have a jury. Only the district court has a jury. The jury determines for criminal cases guilty, not guilty, in civil lawsuits, liable, not liable, and then the judge decides what the consequences will be. Next. So we move up a level to the Court of Appeals, and when we move up a level, there is a huge difference. The district courts, where we determine the facts, versus the appeals in the Supreme Court, in which we determine, was the law correctly applied? Was the Constitution correctly applied? Were the Constitution and the U.S., again, it can only be U.S. laws, not state laws, have the U.S. laws been correctly applied? Next. All righty. Yep, go for it. Thank you.
Hi, everybody. So I'm going to talk about judicial review. That's the power of the courts to review the laws and government actions to determine whether they comport with the Constitution. Are they constitutional? The Constitution is being the supreme law of our land. Everything has to comply with it. If they're not, the law is struck down and no longer given full force. Dis J.D. Vance's recent comments about this notwithstanding, the principle of judicial review is pretty well settled. It was settled in 1803 in a case called Marbury versus Madison, which is a foundation case in U.S. law. It struck down a portion of an act we're going to talk about in a few minutes, the Judiciary Act of 1789. And in doing that, like that, it was about whether somebody's going to get their commission or not after they've been appointed as a judge. But the ongoing effects of that, can I go to the next slide, is that it created this authority in the Supreme Court. It didn't create, it recognized this authority in the court to have the power to review acts of Congress and the president and declare them void if they violate the Constitution. They can also strike down state laws if those state laws conflict with the federal Constitution. We're going to talk about the difference between state courts and federal courts in a bit, but state Supreme Courts, their equivalent courts, determine their state constitution. They interpret their state constitutions. But if a state law conflicts with federal law through the 14th Amendment, they can also be struck down under the Constitution. The Marbury versus Madison decision put teeth into the Constitution, to this idea that the judiciary was a co-equal branch of government. They weren't just going to decide cases. All government actions have to conform to the Constitution, both in terms of our structure of government, separation of powers being a big one, and the rights it affirms in the Bill of Rights. It established that the Constitution is the supreme law of the land, and the Supreme Court is the ultimate interpreter of the Constitution. When we're talking about judicial review, different justices view the interpretation of the Constitution in different ways. Kirsten mentioned that it has changed over time. Its interpretation has. There are the groups referred to as the originalists. That's how they refer to themselves. I think there's some argument about no, they're not really. But they believe the Constitution must be interpreted as it would have been understood at the time it was enacted, or any of its amendments. They want to look at the framers' intent. What did they intend at that time? There's some criticism for this because it really locks the Constitution in amber, and we have to look back to 1789 to see what our rights are. And just as one example of how that can go, Justice Scalia multiple times expressed the view that the Equal Protection Clause of the 14th Amendment, which refers to persons, did not include women or gay men, because the drafters of the 14th Amendment would not have considered women and gay men persons under the 14th Amendment. Other justices interpret a living constitution. That is a constitution that evolves with our current values and social norms over time. Okay, next slide. There are limits on the court's power to strike down laws or government action. We're going to talk about it more in depth, but just as an overview, if Congress disagrees with a decision, it can amend or cure the constitutional defect in a new law. And of course, that new law would then still be subject to judicial review if a case is brought. Or the Constitution can be amended in a pretty lengthy process. And there are canons of construction for the Constitution that say, for one, if you could interpret it so that it does not conflict with the Constitution, you should do that. So there are some checks on the Supreme Court, so they can't just strike anything down, although I know sometimes it seems like they do that anyway. Okay, that's me for now. Back to Kirsten. Next slide.
All righty. And the purpose of this slide is simply to understand the difference between majority, concurring, and dissenting opinion. The majority opinion is the new precedent, and at least 5 justices between the majority and concurring opinion must agree to this. The concurring opinion will be justices who agree with the decision, but have different precedents, different legal reasonings, different interpretations of the laws, the precedents, or the Constitution, but they do agree with the final decision. So one might wonder, why in the world would I even write a dissenting opinion? I've lost. It's not worth the time and the effort. It actually is. A dissenting opinion could be written to express frustration, which we have already seen. It could be written to push Congress and push public opinion, as Sue just said, to write a new law, to cure whatever the problem was to begin with, and to get a new law in place. The dissenting opinion could be written and has been written, and this has actually historically occurred, with the thought that in a future time, the justices would change, the interpretation would change, and the dissenting opinion would actually become the majority opinion. Next. All righty, this is what we have just finished, the merits docket. The session that runs from the beginning of October to the end of June might spill slightly into the beginning of July. What I would like everyone to notice is this is a public docket, a public calendar of cases in front of the Supreme Court, decisions made by the Supreme Court. So the Supreme Court will receive thousands of applications. Please hear my case. Please hear my case. They have to relate to the U.S. Constitution or a U.S. law. This past season, from October 24 to June 25, the U.S. Supreme Court accepted 56. So the chances of even getting accepted are pretty doggone slim. But this is a very public, it's open. Everybody can see exactly which cases, what the arguments are, which precedents were used, the reasoning that was used for those precedents. Next.
And in contrast, we have the what's referred to as the shadow docket or the emergency docket. And it's referring to, which is something that's not a bad idea, right? There are sometimes an emergency decision needs to be made. And what the shadow docket does is it allows a truncated procedure so the court can issue a provisional order that's meant to remain in effect only while it then considers the lawfulness of the challenged action. And as Kirsten was saying, typically under merits cases, the courts get a full, or the parties are able to fully brief the issue to the court. They have the opportunity to engage in an oral argument where they can clarify issues and answer the justice's questions about it. The court, and that's all public. And if you've never been to a Supreme Court argument, it is fascinating for not even just the issues, but just sort of the ceremonial aspects of it. And then the justices issue a decision, a written opinion that details the factual and legal basis on which they reach the decision. It explains their reasoning, why we're saying this is what the law is. And all of that allows the public to see and read what the court is doing and understand its reasoning. It forces the court to explain itself, and the judges sign their decisions. So there's transparency. The shadow docket doesn't have any of that. There's not a full briefing. It's usually the decisions are made with limited information. There's no opportunity for oral arguments. And the decisions are typically summary. They're issued as unsigned orders, and they provide little to no information for the basis for the decision or the court's reasoning. And this has become a problem because, as I said, we want to have an emergency process when we need it, but this has been expanded more recently since the 1980s, and now it's just going a little bit cuckoo to the extent the current court is using it. Can I get the next slide? The shadow docket is problematic because the court is relying on it for broader policy decisions, not emergencies. Emergencies, you think of a stay of execution for somebody who's on death row, or an injunction that's needed, or a stay that's needed to prevent some harm to someone. But the court now is shaping the law outside of its normal legal process that's designed for credibility and transparency. It's changing policy. For example, probably heard of these. The court has allowed this current administration to fire tens of thousands of government employees, discharge transgender troops from the military, end protections for hundreds of thousands of migrants from war-torn countries, all without us knowing who agreed and the legal basis on which they made this decision. They are pretty much stamping their approval on a shift in power away from Congress to the president. A recent decision allows the Trump administration to dismantle the Department of Education. The Department of Education was created by Congress. And that's a huge change to allow the executive branch to reach over into to an agency created by Congress and dismantle it. Justice Sotomayor noted that it's a deep threat to the separation of powers to allow the executive to dismantle a department created by Congress. And they did this even more so. What makes it worse is they did this without any explanation of the basis for it, the factual basis or the legal basis for it. And we deserve to know why these decisions are being made. So there's a lot of consternation and anger about the shadow docket. And next slide, I should have said that earlier, sorry. Okay, the Judiciary Act, switching topics from the the shadow docket. Sorry, I got a little vehement there. Kind of makes me mad just because it's a lot of changes. But I'm going to talk about the different levels of courts. And in Article 3 of the Constitution, it says that it is establishing a Supreme Court and those inferior courts as Congress may from time to time ordain and establish. And so what that means is every court except for the Supreme Court is a creation of Congress. And so the Judiciary Act, the Constitution doesn't establish those inferior courts. The Judiciary Act of 1789 did that. And it created 3 levels of courts. One was I'm going to sort of go in a random order. The courts of appeal. Those are the intermediate appellate courts. They are divided now into 13 circuits. I'm sorry, 11 circuits. We had 9 circuits in 1789, but we're a bigger country now. There's more population now. So now we have 13 circuit courts. 11 are geographic, meaning that their jurisdiction is bound by a particular geographic region. Then there are 2 others. There's the District of Columbia Circuit, which only covers Washington, D.C. Despite having such a small geography, it is often referred to as the second highest court in the land because that is the court where a lot of cases, because it's located in DC, it's the main circuit court for issues of administrative and constitutional law. The other is the federal circuit that hears appeals from all the federal courts involving specialized topics like patent, trademark, and international trade. So then we have the district courts. Originally, there was 13, 1 for each colony. Now there are 94. There's at least 1 district court in each federal district, and the federal districts roughly correspond to the states, but some states have more than 1 district court or 1 judicial district. For instance, California has the most, they have 4. Wyoming has 1. It's based on population, right, and workload for the judges. Generally, the states will have between 2 and 3. The district courts hear both civil and criminal cases. There's some limits on their jurisdiction. Those cases must be governed by federal law. We'll talk about that more later. Next slide, please. There is only 1 Supreme Court, thank goodness, I guess. There are 9 justices today, as everybody got right on the Kahoot, but there's nothing magic in that number. Julie mentioned people have been talking about changing that number, and I want to add that there's nothing really magic about 9. In 1789, there were only 6 justices. The number has fluctuated from 5 to 10 in our history. It was fixed in the 1869 Judiciary Act at 9 justices. And those justices are appointed by the president and confirmed by the Senate in its advice and consent role, the idea being that frees the justices from running for office and from being part of a political branch. Next slide, please. There's also specialized courts based on topic. So there's the Bankruptcy Court, International Trade, Tax Court, and the U.S. Court of Federal Claims, which hears monetary claims against the federal government. And the other thing to mention here is that by giving Congress the authority to establish these inferior courts, the Constitution gave Congress significant power over the judicial branch. It's still a co-equal branch, so this can create some friction between the courts because Congress has the power to define the lower court's jurisdiction. It can define what types of cases a district and appellate court can hear. They can establish the procedures and rules those courts follow in hearing those cases. They can strip courts of jurisdiction. They can abolish the lower courts if they would like to. They can alter the size and structure of the Supreme Court. They control the budget of the courts, so they can impact the judicial branch operations and their funding. And of course, as I mentioned, they play a role in the appointment of judges. They can also legislate how courts interpret a law, and this has led to some friction, as I said, because the judiciary is a co-equal branch. They've established that they are the final decider on whether a law is constitutional and how it should be interpreted, but Congress has the authority to legislate how a court interprets the law, what rules it applies. If it disagrees with the court's interpretation, it can pass new legislation, as I said earlier, to clarify it. But they can also pass laws that say this is the standard you have to apply. And they did that most recently in the Religious Freedom Restoration Act. And the court ultimately struck down part of that and said it's unconstitutional. It violates the separation of powers. You've gone too far in telling us what we can and can't do and what states can and can't do and what standards they have to apply. Congress theoretically could conduct oversight of the judicial branch if Congress was interested in doing oversight anymore. But as I said, the limitation on their power is that the court is a co-equal branch and Congress's actions are still subject to judicial review, which would be undertaken by the judicial branch. So that's it for me for right now. I'll be back with immigration judges.
And this is just a chart of everything that's just been described. Once again, notice the district court is the only place in which one would find a jury. Okay, next. So a little bit more detail. This is the U.S. Supreme Court building in Washington, D.C., although currently there is some scaffolding to renew and strengthen the building. Next. So the judges, the 9 judges, and Chief Justice John Roberts is seated in the middle with the red tie peeking out. And next slide. So this is the decision-making process. This is the process that the 56 cases that were chosen out of the thousands that asked for application. In the black box, the lawyers from both sides submit their legal arguments, the precedents they're going to use, the interpretations they're using. These are very heavy, thick, complicated documents. The justices peruse them thoroughly. Their law clerks peruse them thoroughly. Go to the white box. During the very public oral arguments, media is invited to these oral arguments. This is the justices' time to ask both sides what they really meant. What is your legal argument? What is it you're really trying to prove? And to poke holes in the legal arguments of both sides. It's a very stressful time for the lawyers who are presenting. Hopefully they have done a lot of research. The justices and their clerks have done research based on where they think they might make a decision if they have gotten that far, and they use this as a time to clarify the arguments. Notice the red box. That is the only part of this process that is 100% private. There are no public notes or minutes made from the conference. The justices may freely speak because there is no well, with one exception, but there's no thought that any of this would ever go public. They vote, and when 5 justices have voted, that becomes the majority decision, and one of those 5, 6, 7, 8, or 9 are appointed to write the majority decision. If there are concurring decisions, those justices write those decisions, but they are part of the majority. If there is a dissenting 1, 2, 3, or 4, a justice is appointed to write the dissenting opinion, and that all becomes public. And as Sue mentioned, it's signed. We know exactly who wrote and what the reasoning was. We may agree or we may disagree with it, but it's there for all of us to see and all of us to cogitate, to really think about. Next slide. Please notice in the first cases on the docket, cases on the court's calendar, it only takes 4, less than a majority. So one would ask, thousands of applications are sent. How is it determined which cases are heard? When 4 justices agree that that issue is significant enough for the U.S. Constitution or U.S. law that it needs to be heard, it becomes one of, for this past term, the 56 that are heard. Also, please skip over to the conference. Right after the conference cases, opinions drafted, circulated. Please note, as the decisions are being written, the majority decision, the concurring decision, the dissenting decision, they are circulated among the justices. So one might ask, well, the case was heard in October, but the decision wasn't made public until May. That decision was circulating among the justices and among the law clerks, and the reasoning is refined, defined, and hopefully made airtight, so that once that becomes public, it is a very clear, it doesn't always happen, but the theory is, it's very clear and it's very easy to understand how the justices came to this particular decision. And the majority decision has set a new precedent. It may or may not be one of the biggies of the precedent, but it is a new precedent, a new preceding case now that has been made part of our judicial documents. Next. All right, so Sue talked about the districts, and here they are. The 11 courts of appeals, the districts for the courts of appeals. Sorry, I'm going to use words in 2 different ways here, and that's going to get confusing. I did not mean that. I apologize. So the colors are the different circuits for the courts of appeals. You will see there's also a DC Federal Circuit, a DC Supreme Court. That DC Supreme Court is not the U.S. Supreme Court. That is a different court. And then, as Sue mentioned, each state has at least one district court, and this time I mean district trial court. Next slide. All right, we have already talked about this, and so this is going to end up being a basic review here. The district courts are the trial courts where the jury determines guilty, not guilty for criminal, liable, not liable for civil. The judge gives the consequences based on whatever the jury has decided. Next. All right, Sue, take it away.
Okay, so I'm going to talk about immigration courts. We're talking about them here, even though they are not part of the judiciary. They are actually within the Department of Justice, and they're an administrative court under the executive branch. So they're separate from the Article 3, what's referred to as the Article 3 courts, which are the courts of appeal, the district court, and the Supreme Court, because those were created by Article 3. Immigration judges are employees of the Executive Office for Immigration Review in the DOJ. So immigration judges are part of the executive branch. They are not subject to Senate confirmation. They are not political appointees. They are lawyers hired through the competitive career hiring process and then are appointed by the Attorney General to be immigration judges. They have the authority to exercise independent judgment. However, there is a chief immigration judge who has significant authority over them to evaluate their performance and assign their cases. So one thing I want to suggest is just pause to think about the conflict when DHS is the one bringing the immigration charges. DHS lawyers represent the government, Homeland Security, and the DOJ are all executive agencies. But there is going to be some federal court review. Can I get the next slide? Immigration courts hear cases of non-citizens that the government is trying to deport, which is referred to as a removal hearing, meaning we're going to remove you from the country. This is the primary procedure for deciding whether a non-citizen already in the country can be removed. It's conducted by an immigration judge. There's no jury. It is open to the public and to the press. An important thing, though, is that removal proceedings are not criminal proceedings, they're civil proceedings. And what that means is there are fewer protections. The immigrant is not getting the full protection of the Bill of Rights as it applies to criminal defendants, which are more rigorous than to civil defendants. For instance, they can have a lawyer, but they do not have a right to have one appointed if they cannot afford one. So if they show up without a lawyer because they could not find one or could not afford one, the judge expects the immigrant to represent themselves. And there's no exception for children, which is why you might have seen in the news some very absurd cases of 2-year-olds who were expected to represent themselves in immigration court because they did not have a parent or guardian and they did not have a lawyer. I do want to mention that immigrants do have due process rights under the Constitution, under the Fifth Amendment. It means they can't be deprived of life, liberty, or property without due process. And the Supreme Court has repeatedly affirmed this, most recently in April in a case called Trump v. JGG. And I know I'm getting into the weeds on that, but I think it's important because we're seeing a lot of denial of due process to immigrants right now, and the argument that they're not allowed to have it. Even this Supreme Court has said they have due process rights under the Fifth Amendment. So they have the right to receive evidence against them, present evidence on their own behalf, cross-examine witnesses. Basically, they have a right to a trial before they are removed. Can I get the next slide? Once the immigration judge reaches their decision, either party can appeal to the Board of Immigration Appeals. Fewer than 10% of immigration judge decisions are appealed. Then the board's decision can also be appealed to a circuit court of appeal. So we're going back into the Article 3 courts into the U.S. Circuit Courts of Appeal, and it can be appealed to those courts, decisions about whether they're actually removable for the reasons the government has said, whether their due process rights were violated by the immigration judge or the board. About 15 to 20% of board decisions are appealed. So that does give, when I was saying before, it's all in the executive branch, this does give a second outside branch a review of the executive branch's behavior. Next slide, please. And this slide shows you the different processes for those seeking to immigrate to the U.S. So the what I've been talking about is the immigration courts, which review individuals who are already in the country seeking to immigrate here, or the government is seeking to remove them. They might be seeking asylum. This is showing you the USCIS is the office that's tasked with issuing things like green cards, visas, work permits, naturalization applications, and they establish policies for immigration services. The decisions about whether you get a visa or a green card or work authorization are made by an agency officer, not by a judge. But those decisions are reviewable by an administrative appeals office, and then it can, in some cases, be appealed to a federal court. Next slide, please. We talked a little bit about the qualifications for office. In addition to establishing the courts, Article 3 is what sets out the qualifications. There's no age requirement, there's no residency or citizen requirement that we see in the requirements for Congress or for the president. The only requirement is good behavior. And that's been interpreted to mean they are appointed for life. They can't be removed at will. There has to be some cause through an impeachment procedure. No, you do not have to be a lawyer. You do not have to have a law degree to be appointed as a judge. That being said, all the justices have studied the law at some point. Obviously, some more competently than others. But one reason for this was back in 1789, there weren't a lot of law schools. So having a law degree would have meant a lot of people could not have been lawyers. It was more on-the-job training or mentorships. So the last justice who did not attend any law school was in 1941. So that's, not in most of our lifetimes, but it is within a century. They are appointed for life. The idea, as I said, this frees the judges from the influence of politics. If they're appointed for life, they can't be removed except for good cause, which means they can't be removed because they reach a decision, say the president doesn't like. They can retire where they or they can go senior status where they get a reduced caseload but continue to work. But they get their judicial salary for life. And under Article 3, their compensation cannot be reduced during their tenure. You might remember from the Biden administration, Congress was pretty fond of reducing salaries for some of Biden's executive appointees to $1. Can't do that with the judges because their compensation can't be reduced to protect them. Okay. And now it's back to Kirsten.
Sue, I want to ask you one quick question that came up in the, well, there have been a lot of fabulous questions. Thank everybody. Thank you so much for the great questions. One just really hit me. I know that the emergency docket decisions are temporary until the case makes its way through the courts. Can an emergency docket opinion be appealed?
Well, theoretically, it's going to then become a regular merits case. That's why it's like, we're going to make this decision just to hold everybody temporarily until we can get to the merits of it. In practicality, what's happened is a lot of those decisions become the final decision.
Thank you. And as Sue was talking about the process with the immigration judges and due process for those persons who find themselves with the executive branch immigration judges. Our next session on the executive branch will have more details about this. As someone noted, there's a tremendous amount of information we are putting into this session tonight. So the next session will have more specific information about the due process for those persons who find themselves in the executive immigration judges. All right, so in this particular slide, notice the U.S. Supreme Court is the only U.S. court that has original and appellate jurisdiction. However, please notice that original jurisdiction is very limited. It is only when 2 or more states are involved. For instance, I remember Utah got mad and sued North Carolina. I also remember when South Carolina got mad and sued North Carolina. That ended up in the U.S. Supreme Court, which is great because you've got a great group of 9 listening. The problem is you have nowhere to appeal. The decision is final. Or when ambassadors are involved or where a state is a party. The vast majority of cases that we hear about are under appellate jurisdiction. Okay, next. In the Constitution, jury trials are held where the crime was committed, not where the defendant lives, not where the person who's being accused, not where the victims live, sorry. It is where I committed the crime. I will travel to that state, and that is where the case will be heard. Again, this is for U.S. crimes, not state crimes, only for U.S. crimes. Next. Okay, so I saw this, a few questions about this in the chat. Good behavior means that I have not committed bribery, treason, high crimes, or significant misdemeanors. The House will impeach on a simple majority vote. The Senate will convict with a 2/3 vote. Only 8 U.S. judges throughout the history of our entire United States have been removed from office. Next. All right, Sue did a fabulous job discussing this. This is the foundation, the base, the strength of our court system, judicial review. And that case of Marbury versus Madison, 1803, and Chief Justice John Marshall is a great, great story. This is not in the Constitution, and yet it is the strongest power that the courts have. This is the power they have over the legislative and the executive branches. Next. All right, so I thought it would be fun to talk about just a few of the most significant cases from our viewpoint today in 2025. We've had so much with executive orders. The precedent for executive orders is this Youngstown Steel versus Sawyer, which went against President Truman. He was very unhappy about the final decision, but that was the decision. The decision is if Congress somehow, in terms of budget or law, supports that executive order, reinforces that executive order, then that executive order has strength and the court should support it. If Congress has done absolutely nothing to support that executive order, according to this case, the precedent for executive orders for evaluating executive orders, then that executive order is considered weak and it should be easy for the court to overturn it. Next. All right, coming up into the 21st century. This case obviously significantly altered campaigns and our elections when the justices decided that money is speech. And that gave corporations, unions being a type of corporation, also could put unlimited money into independent advertising and campaigns. Next. Okay. Oh, okay. We're going ahead to Shelby versus Holder. No problem whatsoever, because there are a lot of cases here. This is the case that allowed those states that had had to show the executive branch any law they were going to pass about voting had to be pre-cleared, had to be approved. And suddenly the court decided, oh, no, there's no problem with elections. States can pass whatever they want. And so suddenly we have a lot of laws passed about voter ID, a lot of laws passed about early voting, absentee ballots. That is now possible for states to pass, and there is no oversight on that. Next. This we're tremendously familiar with because the effect on women's health has been highly, powerfully significant. Next. All right, gerrymandering has been in the news. Notice this is 2024. This is a rather recent decision. And in this decision, gerrymandering was made easier. Partisan gerrymandering has been legal for a number of years. Racial gerrymandering has been illegal. This particular decision made defining racial gerrymandering much more difficult, which means that's why Texas and California, both of those legislatures are engaged in redrawing their district lines. Normally, the district lines are only redrawn every 10 years based on the census, but Texas and California are redrawing. Next. Okay, this case reduced the power of executive departments, which is the theme of our next session, not the executive branch. The president still has power, and this actually gives more power to the executive because it reduces the executive departments where the civil servants work. Those persons, and again, this will be part of the next session, those persons who hold their job through whoever the president happens to be. Next. Okay, this is the case that gave the president immunity. And notice that absolute is bolded. Because of that, I also included on the next slide the dissenting opinion. And it occurs to me that the possibility that Justice Sotomayor wrote this dissenting opinion, I believe she feels that this immunity will be revisited. It would not surprise me if her dissenting opinion becomes part of a new precedent further down the line when there are different justices on the court. But currently, that Trump versus US, written by Chief Justice Roberts, is the new precedent about presidential immunity, and it definitely gave the president more power. Next. This is an extremely recent case. The universal injunctions were the one way that district court judges, and remember, as Sue explained, every state has at least one district court. So just one district court's judge was allowed with a universal injunction to stop an executive order. This prevents that. However, Justice Coney Barrett left a loophole, and we already have several groups forming class action lawsuits and have jumped right into that loophole. But the main idea is the power of district court judges to prevent universal injunctions has greatly diminished. So I included next the dissenting opinion. Again, I believe that this dissenting opinion was definitely written out of frustration, one reason to write a dissenting opinion. I also believe that Justice Jackson hopes and sees that the opinion is on such shaky legal grounds, as is Trump versus US, that both dissenting opinions will eventually become the basis for a new precedent, a new majority opinion down the road in the future. Next. All right. Sue, may I tell one quick story?
Sure.
So I have a friend, her husband is a U.S. tax lawyer. He was representing the husband in U.S. tax court. The wife of the husband committed a murder, and she was in a state court. So Sue's going to explain how that happened. Thank you, Sue.
Oh, okay, yeah. Oops, wait a second. I went to the wrong page. Hold on just a second. So yeah, state courts and federal courts, state governments and the federal government are all separate sovereigns. So state courts have separate judicial systems from the federal system. There is some overlap that I'll talk about in just a second, but they are separate. And this is why, for instance, if you're all familiar with the double jeopardy clause that says you can't be tried twice for the same crime, that does not apply if you are charged by the federal government and by a state government for the same crime. That's referred to as the dual sovereignty doctrine, because you are not being prosecuted twice by the same sovereign. You can be prosecuted by your state and by the federal government. And that came in handy during the civil rights era in a lot of situations where some states were not prosecuting crimes that were committed against Black Americans. Every state has its own court system, as do the territories and many Indian tribes. They tend to follow a similar structure to the federal system, where they have trial courts, intermediate appellate courts, and then a state Supreme Court. They might have different names. If you're in New York, I'm sorry, you have names that are just kind of cuckoo banana pants to me, where the trial courts are referred to as the Supreme Courts, and what we would call it the court of last resort is referred to as the Court of Appeal. I don't know what to tell you, but it's just different than most every other state in the union. So states also have specialized courts like traffic court, probate court, and family court, because all of those are governed by state law. So those are not federal law issues. They do not have tax or bankruptcy court or immigration courts, because those are all federal issues, and the federal law is supreme when it takes over an area of the law. State courts have broad jurisdiction, broader than federal courts do. They can hear a wide range of cases, including criminal matters, family law, civil matters that arise under state laws, state constitutions, and regulations. They can also hear cases arising under federal law. That typically happens if you sue, say, for example, for workplace discrimination under both a state and a federal anti-discrimination statute. In those situations, the state court has to follow the federal court case law in applying federal law. Likewise, well, we'll talk about when federal courts hear states. Similar to the federal system, a party may appeal to an intermediate reviewing court as of right, meaning you get an automatic appeal, but the review by the highest court might be discretionary, like it is with the Supreme Court, where you have to actually ask, will you hear my appeal? One big difference between federal judges and many state judges is many state judges are elected rather than appointed, meaning they run for office and the citizens vote on them. There's a lot of downsides to that, particularly in a country where a lot of people don't understand the judicial process. But some states also do an appointment. Georgia does. There's some judges who are appointed and then they can run for reelection. Okay. We talked about federal courts and their limited jurisdiction, but I do want to mention, no, I'm going to mention that later. Sorry. So next slide. The next slide. Yes.
Brady, I think
No,
we've
no.
pretty much gone over this. It's this year, Sue, sorry.
Yeah, no, yeah, we did go over this, right? So,
Yeah.
earlier. Okay, so we don't need to go over that. But additional things to know. So this idea of lifetime appointments can be really frustrating to people. The judges are appointed for life. But the idea is not just to let them keep their nifty salary until they pass away, but it's to free them from the influence of politics, meaning they can't be fired for not reaching a popular decision. One thing that the courts are designed to do is be some protection from the tyranny of the majority, meaning unpopular cases, unpopular parties can get a fair shake in a federal court because the judges won't be fired or won't be voted out of office for protecting the rights of someone that other people don't think should be protected. But the idea that federal judges are free from politics is a little bit nonsensical. We've seen this idea, we've seen the process for appointing judges at the federal level be perverted by politicians, most recently Mitch McConnell, who held up Obama nominees as much as he could during Obama's time in office, hoping for a Republican president, and then pushing through as many Trump appointees as he possibly could, and selecting very young judges because it's a lifetime appointment. So appoint judges in their 30s, and so they will be on the bench for 50 or 60 years. So that can be manipulated, but every system can be. And as I said earlier, the independence of the judiciary, they are independent of the other branches, but Congress has oversight. They set their judicial salaries, But Article 3 says you can't reduce it during their tenure. And that will help prevent Congress from punishing judges for reaching unpopular decisions. Okay, next slide. Oh, we got that. Okay, impeachment. A lot of you have been asking, can't we impeach Thomas? Theoretically, yes. Judges are subject to impeachment. Article 3 mentions good behavior. That is not a separate impeachment standard. The standard is still the one we're familiar with: treason, bribery, and other high crimes and misdemeanors. Does not have to be a criminal offense. And it follows the same process, which is why it's theoretical right now, because there has to be a formal accusation of wrongdoing in the House that is voted on by a majority. And then there has to be a trial and conviction in the Senate. And that is just unlikely to happen while Republicans control Congress. As Kirsten said, 8 judges have been removed, 15 have been impeached, but only 8 of them were removed. And just for no particular reason, I want to mention a couple of examples. Robert Archibald, who was a Third Circuit judge, was impeached for improper business relations with litigants. Alcee Hastings was impeached for conspiring to solicit a bribe. Thomas Porteous was an Eastern District judge in Louisiana. He was impeached in 2010 for accepting bribes. But all of them were convicted and removed. So it is possible to remove judges for inappropriate behavior or seeking to basically earn money off of their office. The other limit, as we've talked about, they can only decide cases that involve the U.S. Constitution, federal or statutory administrative law, executive orders. They can federal courts will will handle state law matters in diversity jurisdiction. And diversity jurisdiction is when you have a plaintiff from one state and a defendant from another state suing each other. They can sue in federal court as long as the amount of damages they're seeking is more than $75,000. Then the federal court will resolve the claim by applying state law. And there's one reason I wanted to mention, well, there's 2 reasons I wanted to mention this. One is that when the federal court does that, they are actually bound by state law. They have to follow state law precedent. And the federal court's decision is not binding on the states itself. And so that gets back to the idea that these are 2 separate jurisdictions, and the state Supreme Court is the ultimate determination of the law of that state. The other reason I mention it is that I think it suggests the framers didn't think a citizen from one state would be fairly treated by the citizens on a jury of another state. And that distrust has been called into question, but I think right now in the times we're in, especially, it probably seems still pretty palpable and pretty reasonable assumption. Next slide.
I think we only have a few slides left. I'm just going to note we're actually over time.
Yeah,
So
I'm sorry, I'll go faster. Okay. So the first one is you can't rule on legislation or executive orders unless a case is brought before them. That makes sense, right? The Supreme Court can only hear actual cases referred to as real cases or controversies. They are not allowed to issue advisory opinions. For a case to get to the Supreme Court, 4 justices, we've talked about that already. And because of those first 2 things, the justices don't review all laws passed by Congress, because there might not ever be a suit. Or there might be a suit and a circuit court decides it, and the Supreme Court, just 4 of them don't think it's worth taking, and it never gets to the Supreme Court for a final decision, which means the appeals court decision would then stand. And then next slide. This courts have very little power to enforce their decisions. This is one, I guess, weakness. The reason we follow court decisions generally is we have respect for the rule of law. We understand a court decision should be binding on us. The biggest power the courts have to enforce it is their contempt power, where they can hold somebody who is disobeying a court order either criminally in contempt, which means they'll be subject to jail, or in civil contempt, which means they have to pay money to the other party. But the federal courts have no police. They have no army in order to actually have any teeth in that. And there's this likely apocryphal story of Andrew Jackson saying after John Marshall said that the state of Georgia did not have jurisdiction over an Indian tribe, John Marshall has made his decision, now let him enforce it. He probably didn't say those words, but he did disagree with the decision, and he thought the federal government had no authority to enforce this ruling against Georgia. But I bring it up because it raises the fundamental ideal of our legal system and the rule of law. As I said, we obey court orders because we recognize we're a nation of laws and that we're bound by them. And the courts need to be perceived as legitimate, fair, and impartial for that to work. And I think we are in danger of losing the respect for the rule of law. And that's me done. Yeah.
Oh, I'll say it. 2 quotes. This feels so depressing, and I have read a few comments about participants saying, oh my gosh. So 2 quotes from 2 people who have endured quite a bit. And I think we can look up to them and take their quotes with credibility and with validity. So this is John Lewis, and this is Justice Jackson. Please notice the final line. That is critical for us to understand her thoughts and her exhortation to us, please. And that's it. Thank you, Julie. Thank you, everybody. Thank you, thank you, thank you.
Thank you. I know that was so much information. So obviously we usually keep it within the hour, but we went a little over, and I didn't even play the funny comedian videos because I'm like, oh no, we'll be here till like 9. I'm just gonna go through a couple of the questions real quick because there were a lot. Someone asked about the unitary executive theory. I think we covered that in one of our other sessions. So go back to our YouTube channel, look under civics, and you can watch some of the old recordings. Someone asked about countering SCOTUS decisions, like who do you call? You can't really call anybody. You can call your congressperson and tell them that you want a law to counter something, that maybe the court has decided, but that the court makes those decisions, and we really can't call and influence justices like that. We've already answered the shadow docket. Yes, district and appeal courts do have judicial review. They're all reviewing everything, and then it's going up the line for final decisions. Do you know why the Supreme Court gets the summers off? Somebody asked.
They actually do some work during the summer, believe it or not. So, Sue, you better answer that. Sorry, you're better.
No, go ahead. Yeah, no, they do. I mean, it's the first Monday in October through about the end of June is just their calendar period when they're hearing cases and issuing opinions for each term. But then after the term, they are presumptively still,
they're reading research.
Sometimes they're reading the petitions. They're already receiving petitions now for the October term that will be coming up. And so they're spending their time doing that, or their clerks are at least.
Are there rules or is there legislation or rules around the shadow docket, or is this really just their discretion and their own rules?
It's their discretion right now. And I think that's why there's a lot of writing about this. I think Dahlia Lithwick has written quite a bit about it, and others, because again, I think it was a good idea, right? We do need to make emergency decisions sometimes, and trial courts do this all the time. But the Supreme Court, because it can have this fundamental altering effect about our structure of government and what we perceive as constitutional or not, using it to make policy decisions is frightening. And maybe there's some reform, but somebody pointed out in the chat, the last time we brought up reform of ethics for the Supreme Court, that didn't really accomplish much. So,
another question that I thought was interesting that I don't even know the answer to, and I'm a lawyer. What kind of cases go to the Court of Claims?
Those are cases that are basically you're suing the federal government for a harm where you're seeking money damages. So it might be like a claim against the military. One case that I read that I teach in remedies, somebody was injured by a military personnel in a car accident. And so she was suing the federal government for monetary damages, as opposed to the more typical is an injunction against the government. And I do want to say, when I was talking about the shadow docket and I seem sort of negative about it and sort of defeatist, it doesn't mean that Congress can't regulate what the court does with the shadow docket and require that it, or eliminate its making policy decisions. I don't think this Congress is going to do that because they like the decisions it's making, but future Congresses could do that because they can limit the court's jurisdiction and they can expand it and they can prescribe rules. So that's something to focus on.
Someone asked, you just mentioned somebody in regards to the shadow docket. They were asking who the writer you mentioned. Oh,
Dahlia Lithwick.
Dahlia Lithwick. We've had her on before. You can go look that video up on YouTube as well. Yeah, Lithwick, Lithwick. I think that was really most of the questions, because a lot of the ones that were being asked in the chat, you guys then went on and answered with their presentation. And I know we're 15 minutes over time. So I am happy to take further questions. If you're really confused about something, you can email me at julie@redwine.blue and I can get answers for you, because I know this is a lot of information. So thank you all for joining tonight. Thank you so much to Kirsten and Sue, who get me all this information. We put it together. They go through and edit it. So this one was a big one. But like I said, tell your friends, join us, and everybody have a really great rest of your evening.
Thanks, everybody. Thank you.
Bye.